Okay, welcome to the afternoon panel. I'm honored again to be sitting with Judge Clement and Judge Holt. We have two cases for oral arguments this afternoon. The first case is 23-40197, Palmquist versus Hain. Mr. Post, you're up, sir.
Good afternoon, and may it please the court. I'd like to begin my remarks today where this court ended in its en banc decision in Smallwood regarding fraudulent joinder, with this statement: our insistence that diversity removal, powerful as it is, remain within its congressionally marked traces, is demanded by principles of comity and federalism that a state court is to be trusted to handle the suit unless the suit satisfies the removal requirements. This case does not satisfy the removal requirements, and in accordance with Section 1447C, Congress has directed that it shall be remanded. The case involves claims between the Palmquist family, Hain, and Whole Foods. Whole Foods and the Palmquists are indisputably both Texas residents. The state court petition alleged claims of negligence and breach of warranties against Whole Foods. Those were viable claims. And after removal, the Palmquists amended their complaint as a matter of course to clarify the allegations against Whole Foods, not to add new causes of action, but to clarify the basis of the claims that were already pleaded.
You acknowledge in the second complaint negligent injury or negligent whatever wasn't in the first.
Negligent undertaking.
So that was a new claim.
That particular cause of action was new, and we acknowledge that Judge Brown correctly disregarded it. But negligence was pleaded, breach of warranties were pleaded, and statements that constituted express representations that the products were safe and highest quality were pleaded in the state court petition. And the amended complaint elaborated on those allegations to demonstrate that they were viable. Now, the district court here refused to consider the amended complaint, alternatively held that it did not state a claim under Texas law, and then dismissed Whole Foods with prejudice. All three of those rulings were erroneous. And because the jurisdictional ruling here is dispositive of the case and is important not only for these litigants but for litigants in the circuit going forward, I'm going to focus my remarks on the jurisdictional issue today.
So which of the complaints, do we agree the complaint, the initial complaint, and I understand first, second, because it was amended before, but I guess I just say first and second. The original complaint, if you will. Is that the one we're focusing in initially?
Your Honor, I would like you to focus on the second amended complaint, which was the First Amendment filed in federal court, because I believe under this court's precedent, it is necessary to look to that complaint. I wanted to establish the foundation that the petition that was on file at the time of removal itself alleged negligence and breach of warranty claims against Whole Foods. But we believe it is the second amended complaint, the amendment after removal, that should be controlling here. And the reason for that is that it is dictated by the logic of this court's decisions in International Energy Ventures and the Pena decision. Obviously, we all agree that the question of improper joinder is determined under a Rule 12b6 standard. And in International Energy Ventures, this court determined that that means that you must apply the federal 12b6 analysis to the determination of improper joinder. That is materially different than the analysis that is applied to a Texas state court proceeding, which requires only fair notice pleadings. And I think what's important to recognize about the Texas standard is that there is no Texas decision that I can locate that has ever held that a plaintiff must anticipate a Chapter 82 defense under the product liability statute and plead a theory of avoidance to that defense. And in fact, even if you take the view that Chapter 82 constitutes an essential element of a plaintiff's claim, the Texas pleading standards are well established that even the omission of an element is not fatal to a claim if it can be reasonably inferred from the facts, as it could have been here. And so you have a situation where the rules under which the case was pleaded originally in state court are perfectly compatible with the viability of this claim against Whole Foods. And admittedly, the federal standard, which International Energy Ventures says must be applied in this context, establishes a higher pleading threshold. And in those circumstances, we think it is inescapable that a plaintiff, upon removal, must have the opportunity to amend, to clarify its allegations. And I think that's true for two reasons. The first reason is that I think it is essentially commanded by this court's holding in the Pena decision, because in Pena, the court held that after removal, when a plaintiff's allegations are challenged under Rule 12, the plaintiff is entitled to an opportunity to amend to satisfy the pleading standard imposed by federal court. And Pena relied on International Energy Ventures, and it specifically refused to distinguish between a merits-based determination and a jurisdictional determination. And so I see no logical way to fail to apply the rule of Pena to the context of improper joinder. Second, and independently, that conclusion is perfectly consistent with this court's jurisprudence regarding improper joinder. We all agree that the status of federal jurisdiction is determined by the jurisdictional facts at the time of removal. But what those facts are at the time of removal can be clarified by post-removal events. And I want to particularly analogize this case to the Banc decision in 1993 that Judge Garwood handled, because that was a case that had originally been filed under Texas law in Texas state court. And in Texas court, it was not appropriate to plead the amount in controversy in the state court petition. And so when the case was removed, the question was, does the case satisfy the amount in controversy requirement? And what Judge Garwood held in that case is that it's appropriate to allow a plaintiff to clarify the jurisdictional ambiguity because there was no obligation to have pleaded those facts in the first instance in state court. And so what we have here is essentially the same sort of situation. You have allegations of negligence and breach of warranties. You have reference to express representations that were stated in the state court petition. And what happened in the amended complaint is those allegations were clarified to demonstrate that they state plausible claims against Whole Foods. This is not a case like the Cavallini case in which a plaintiff tried to add new claims after the removal to defeat federal jurisdiction. All we have tried to do, and I think done so successfully, is to clarify the basis of those claims.
What do you? No.
Of course, Your Honor.
It seems to me it would clarify things if those two doctors would have testified. Why didn't they testify?
The toxicologists, Your Honor? They didn't testify because as the case developed, their testimony was unnecessary. We had gotten the testimony that we determined was necessary from Hain's own toxicologist. The facts are scientifically here that there's an unusual duality. It is accepted by experts on both sides of the case and the parties on both sides of the case that there is a causal relationship between heavy metal exposure and neurocognitive injuries. It is also accepted that the precise threshold of harm is unknown. Science has not established it. And when asked this question in the examination at trial, Hain's toxicologist admitted that there is no known safe level of exposure. And I would call the court's attention on that to page 21,788 to 89 and 2186. That's the testimony of Dr. Kyle, Hain's own toxicologist. And so the reality, Your Honor, is that we don't really have a dispute about what the state of the science and the state of the evidence is. Everyone has to agree that a causal connection exists, and everyone has to agree that the threshold of harmful exposure is unknown and science cannot determine it because it wouldn't be ethical to conduct the studies to determine the threshold of exposure. Now, all of that said is that's a question for whether this state law claim can survive under Texas law. If Hain is so confident that our claim is not viable under Texas law, it should not be reluctant to go litigate that case in the Texas courts where it can vindicate its position. The point is that, as Justice Scalia said in Grupo Dataflux, if jurisdiction does not exist, then the court can't decide the merits, and considerations of economy, efficiency, all the things that I'm confident the court is going to hear about from our friends on the other side are no answer to a jurisdictional defect.
Which is the argument? Is it that the plaintiff's second amended complaint was a, quote, clarification or an amplification of what was filed in state court? Or is the argument, if not, once removed, your client had a right to amend via the second complaint and add or state the other claims?
The argument, Your Honor, is the first, that the second amended complaint clarified the viability of the allegations against Whole Foods. And let me explain how that is so. Because, as I've indicated, claims for negligence and breach of warranties were pleaded in the state court petitions, and facts that related to representations made by Whole Foods had been pleaded in the original petition. But nothing specific about the Chapter 82 exception for an innocent retailer had been pleaded in detail. And so what happened in the second amended complaint is that the plaintiffs elaborated on those allegations to demonstrate that there were viable bases to conclude that Whole Foods had made factual misrepresentations. And specifically what the amended complaint pointed to were the statements that not only that Hain's baby food is safe and, quote, of the highest quality, but that Whole Foods carefully vets its products to avoid harmful ingredients.
All right, I see you there, but I want to be clear. The first complaint, which says original petition filed in Brazoria County, Texas, that's the one I should be looking at, right?
No, Your Honor, that's the original petition filed in state court, and the amended complaint in federal court is the one that elaborates on those allegations.
Oh, no, I got you. That's the one that says plaintiff's second amended complaint.
Correct.
Right. But when I'm going at the complaint filed in state court.
That would be the original petition.
Right.
And then there was a first amended petition in state court
state
prior to removal.
But that complaint in state court expressed the claim based on, quote, implied warranty, right?
Your Honor, I think that petition actually alleged both forms of warranties. First of all, it's important to recognize that it specifically stated a claim for negligence, right, independent of the warranty claims. It then stated claims for breach of warranties, and those allegations included both statements about implied warranties and included statements about express statements that had been made by Whole Foods regarding these products. And so the point is that then the amendment in federal court clarified those allegations by explaining how they meet the federal pleading standard.
I can see your argument in terms of clarifying, quote, plaintiffs relied on Whole Foods representations. Where I'm having trouble understanding clarification is that in the original complaint, it pled, quote, implied warranties, whereas in the second amended complaint, it begins to talk about express warranties. So I'm trying to understand how that's a clarification. Do you follow me?
I do, Your Honor, and I think I would emphasize that at the time of removal, it was the first amended petition that was the live petition. That petition included, yes, it referred explicitly to implied warranties, but it also included factual statements that referred to express representations. And under Texas practice, that was sufficient. And if you look particularly at page 169 of the record, you'll see references to the statements that the baby food was, quote, safe and highest quality. And
so is the idea basically it could have been, I don't want to say sloppy, but it could have been more precise?
Yes.
There was a mismatch between the legal pleadings, the legal paragraphs, and the factual ones, but the point is you could see the contours, and then the next one fleshed it out.
That's exactly right, Your Honor, and it's fair notice pleading based on the facts. And so then when we clarify the facts, there are three ways in which those factual allegations state a viable claim against Whole Foods, and I want to touch on each of them briefly. Number one, the only Texas cases that have applied Section 82.003A5 have allowed allegations to state a viable claim on much less precise allegations than are present in our case. And I point to the Transcontinental Insurance Company case and the JSC case cited in our briefs. Why is that important? Because 2 years ago...
JSC was a jury trial case, $3 million verdict, right?
Exactly, Your Honor, and the court upheld the verdict based on evidence that was established only that the representation had been made that the product was of a certain grade. That's perfectly compatible with the allegation that Whole Foods represented that these products were of the highest quality and free from harmful ingredients. And the point to be made here is this court's decision in D&J Investments in 2022 said because we can identify a Louisiana decision that recognizes the possibility that this claim is valid under principles of federalism, we must remand it. That same rule is applicable here. Number two, the Texas Supreme Court has for generations held that even fairly general statements about products can state a viable claim. The Pennington decision in 1980 is the leading case. It remains Texas law. They have no answer. Number three, the Texas Supreme Court, as recently as Italian Cowboy in 2011, held that when a speaker has special knowledge, which is exactly what Whole Foods represents to its customers and what was alleged in this complaint, the representations of special knowledge are actionable at common law, which means they are actionable under the statute. The defendants have no response. Jurisdiction does not exist, and this case should be remanded.
All right, thank you, Mr. Post. You've reserved your rebuttal. First up for Hain, Mr. Schmidt.
Yes, Your Honors. Thank you. May it please the Court, Paul Schmidt for Hain. Each of the plaintiff's three remand arguments is contrary to black-letter law, and they have no response to fundamental failures of proof on three different aspects of their causation case. Subject to the Court's question, those are the two broad issues I'll focus on, remand and causation. Starting first with the remand arguments. There are three distinct bases for rejecting those arguments. The first was the district court's holding that the plaintiffs could not amend after removal to try to defeat federal jurisdiction. Applying black-letter Fifth Circuit law, like the Cavallini case, a complaint amended post-removal cannot divest a federal court of jurisdiction. There's been no argument in the briefs or before the court that that complaint as removed defeated federal jurisdiction. The argument is they had to have been allowed to amend.
Well, the district court went ahead and talked about it anyway. Does that matter?
No, it doesn't. I do want to address that issue, Your Honor, as the second basis for rejecting the remand arguments. But the district court was clear it didn't need to get there, and this court doesn't need to get there because the case law that the plaintiffs are invoking to try to claim a mandatory right to amend these two cases about amplification of allegations in the complaint as it existed at the time of removal clearly don't apply here. And we know that because if they were simply amplifying their allegations as they existed at the time of removal, they would have filed an affidavit, which is what happened in their two cases, Griggs and Anpak. But they couldn't do that. They had to amend because they were asserting new claims. And as Your Honor recognized, Judge Stewart, they changed an implied warranty claim at the time of removal to an express warranty claim. The petition as removed, the first amended petition, they'd already been able to amend once in state court, was very clear in asserting an implied warranty claim. It talked repeatedly about implied warranties. The one paragraph that the plaintiffs referenced the court to in argument at page 169 is preceded and succeeded with allegations about implied warranties. There's no express representations referenced anywhere in the complaint at removal. I'm sorry, Your Honor? They went from, yes, Your Honor, from an implied warranty claim to an express warranty claim. And they needed to do that to overcome the Texas innocent seller statute. Of course, an implied warranty claim can't meet the Texas innocent seller statute. So after removal, they alleged an express warranty claim.
His original complaint does talk about representations or misrepresentations, separate and apart from the implied warranty part. And, you know, that arguably, if you say the second one was meant to clarify that, so I get you on the implied and the express, but on the representations, they did seem to consistently urge representations by both parties. What do you say?
I don't think that's a fair reading of their complaint. In paragraph 62, that's the paragraph that they referenced during argument, that my colleague referenced during argument with these implied representations. Both before that, in paragraph 61, and after that, in paragraph 63, they make clear what they're challenging is Whole Foods' implied warranty was incorrect, given the high levels of heavy toxic metal Hain's food, baby food products contained. They end this claim by saying the same thing. Plaintiff's injuries were sustained, were caused because of Whole Foods' implied warranties. That's a different claim than an express warranty claim. When they came back with their amended complaint, they pled an express warranty claim to try to get around the innocent seller statute with express representations, and they dropped tellingly. They dropped the implied warranty allegations. That's a different claim. If something is expressed, that's the opposite of something that's implied. That was a separate claim that fails, even under the case law that they cite. Even the case Griggs that they rely on heavily says if there's a new claim or theory, that can't be added after renewal. This is a new claim. It's certainly a new theory under the Griggs language. They themselves concede in their briefs that if it was a new claim, it was improper, and that obviates the need to reach the international energy decision that they spend time critiquing in their brief. That's the first basis for defeating the remand arguments. The second is...
Well, let me just ask you one other. I mean, there are lots of cases out here on it, and our cases do say, number one, as you said, we're looking to original complaint, but it also, the cases, I can't remember which one it is, but it essentially says if there's, quote, ambiguity or if there's uncertainty as to state law, et cetera, that the burden is heaviest on the one claiming improper joinder, and that the complaint should be viewed from the standpoint of our standard, whether it's implausible or plausible. So stated another way, our cases do consistently say, since Smallwood, that it is the plausibility standard, and just separating for the moment the implied versus the express.
Yes.
But the other arguments made about representations by Hain, by Whole Foods, et cetera, wouldn't that seem to fit within what our cases have said? In other words, if it's closed or if it's unclear whether Texas would allow a claim under the remedies, under that prong, that the doubt, if you would, should go towards the remand. I mean, I'm just asking.
Yeah, I think that goes to the second remand point.
Okay.
It doesn't affect the first remand point that they had to amend, and that alone is cause to reject their remand arguments. But as Your Honor noted, the district court did proceed to consider their amended complaint in the alternative and found that it didn't defeat federal jurisdiction in terms of overcoming the innocent seller statute. Both the text of the statute itself and the cases both sides cite make clear they had no basis for overcoming the statute. The statute itself requires something factual, that's more than an opinion, more than a generic statement, and that is not just about the product at issue, but about an aspect of the product. It's got to be specific in a way that links up to their claim. And they don't have that here. The cases they cite illustrate that very point. The cases we cite illustrate that point. Our cases and the cases the district court relied on make clear that the representation has to be more than just a statement that something is good or usable or something like that. That's not enough.
Well, I looked at some of those cases, and even the case that the district court cites, I guess it's Lowe's, I think, cites to the trans case, and the district court says what you said in the cite. He says, you know, generalized statements, puffery, et cetera, is not actionable. But then he says, but contrast this case that he cited, which was the jury, the $3 million jury verdict, but say where the representations are more than just generalized and it's more than puffing, then it may be actionable. In their complaint, the second or otherwise, they go through the whole laundry list of Whole Foods website and on and on and on with details and so forth. I guess my point is, it's hard for me to see that as, quote, puffing or the generalized statements that the Texas cases seem to have been talking about, where somebody just said it's a good product, you'll love it, you know, it'll last forever. So help me find the sweet spot.
Yes, Your Honor. I think it is instructive to look at their cases because, number one, their cases involve statements about a specific product. There was no statement about a Hain product here.
Well, they cite somewhere in here where they specifically enunciate where they talk about Hain's, in other words, just generally saying we sell the best products in the world. Somewhere in here he pleads that Hain's products or food, specifically the name Hain's. It's escaping me now, but and I could be, you correct me.
They don't have anything from Whole Foods.
Okay.
In products. They have statements from Whole Foods on their product lines generally, and they have nothing from Whole Foods that tracks to the specific aspect of the product, using the statutory language, that they are criticizing here, heavy metals. And their cases kind of highlight that disconnect. The JSC case, there was a representation that something was P110 grade when it was alleged it wasn't. The Pennington case that was mentioned, there was a representation that a boat was in perfect condition when it actually had a cracked gear housing. The Helena case they cite, there was a representation, all kinds of facts about crop seeds. They were tolerant to charcoal rot. They had excellent yield potential.
So you would say that there are allegations about heavy metals and toxicity of the baby food would not be an aspect of the product as those cases speak?
If there was a statement about Hain's products that Whole Foods make, that could be. There's no such statement. There's no statement about a Hain's product. There's references to ingredients, but there's no statement about heavy metals or about purity testing or contaminants or trace elements, anything like that. And that falls squarely outside of the cases they cite. I want to turn, if I could, to the third remand issue, the Caterpillar issue. The plaintiffs asked this court to impose a restriction on Caterpillar as only applying to voluntary dismissals when the unanimous Supreme Court did not apply that limitation on its own holding. That's contrary to Caterpillar itself. It's contrary to this court's precedent. It's contrary to precedent from other circuits. In terms of Caterpillar, Caterpillar was a voluntary dismissal case, but that wasn't the basis on which the court ruled. In fact, it did the opposite. In justifying its rule, it cited the ability of courts, including appellate courts, under Rule 21 to dismiss dispensable, non-diverse parties. That's an involuntary dismissal. It makes no sense to say Caterpillar justified its rule based on involuntary dismissals, but it actually only meant it to apply to voluntary dismissals. And of course, that's nowhere in the core holding of Caterpillar, which is that when you go through trial, considerations of finality, efficiency, and economy become overwhelming. In terms of Fifth Circuit precedent, they cite three cases: McKee, Williams, and D&J Investment. Only McKee involved a trial, so only McKee is on all fours, or could be on all fours with Caterpillar. Not one of those cases, though, addressed Caterpillar. And there's a reason. It wasn't briefed in those cases. And as even plaintiffs acknowledge at page 7 of their reply brief, where an opinion fails to address a question squarely, we will not treat it as binding precedent. What is binding and guiding here is this court's precedent in the Exxon decision, where it looked at this voluntary-involuntary argument that the plaintiffs have made here in the context of Caterpillar, and it said the voluntary-involuntary rule is inapplicable in this setting. It simply raises the wrong question. In this setting, the relevant question, the relevant consideration becomes whether the action has either been adjudicated on the merits or alternatively has remained in federal court long enough that considerations of finality, efficiency, and economy enter into the equation. That fundamentally rejects the involuntary-voluntary rule that the plaintiffs asked the court to impose on the Caterpillar decision. The same is true for precedent outside this circuit. They cite the G.E. Betts case from the Seventh Circuit, which is plainly distinguishable. The diversity problem there was never cured. It was in federal court 3 months before being dismissed on motion, not after trial. Other circuits have applied Caterpillar to preserve judgments after involuntary dismissals. We didn't have a chance to cite these because this argument was first raised on reply, but it's the Brown case from the Second Circuit, 654 F. 3rd 347, the Junk case, that's really the name of the case, from the Eighth Circuit, 628 F. 3rd 439, and the Sync Labs case from the Third Circuit, 838 F. Appendix 665.
When it says all over, why don't you just send us a 28J with those cases in it?
Yes, yeah, and I apologize for not doing that. We thought about doing that. They all predate the briefs, which is why they didn't seem like they fit squarely within 28J, but we will do that. So those are three black-letter law independent bases for rejecting the remand argument. They can't amend. They fail under the innocent seller statute because they don't have specific challenges to a product or an aspect of the product that they're challenging here, and in any event, Caterpillar would overcome an improper remand ruling in the first instance by the trial court. In terms of the merits on causation, I want to touch very quickly on three fundamental failures of proof relating to causation in their case. The first two relate to this question of dose. Was there enough heavy metals to cause the injury they claim? There's both a general causation aspect of that, did they show the level that's required, and a specific causation aspect, which the district court didn't need to reach given its general cause ruling, but this court can, of course, affirm based on was Ethan exposed to enough. In both instances, Texas and this court's precedent recognize both are required. They had to prove the dose. Texas cases like Helena just last year from the Supreme Court, Bostic, Flores, cases that reject their argument that this is a procedural question and not a substantive question because those Texas cases state this dose requirement as a substantive component of general causation law and give substantive policy reasons for doing that. Otherwise, you have strict liability for substances, like in those cases, asbestos, that are everywhere, that people are exposed to everywhere. This court's precedent is the same, Curtis and Allen. Their experts conceded that they had no testimony on those issues of either what dose is required or was Ethan exposed to enough of that dose. And what's notable about that is they had gone to trial representing that they would have experts who would cover those points. They told the jury at the beginning that they would call one of those experts, Dr. Perrin. Dr. Ashner was the other. They made the judgment during trial not to call those witnesses, to talk about those two critical questions. What was the dose? Did Ethan have that dose? And without those experts, they had a fundamental gap in proof in their case.
Opposing counsel said they had the evidence. What was your-
No, I think the statement and what they argue in their briefs was, well, there's a recognition that there's no safe level. That's true for any number of substances, including substances far removed from baby food. There's no safe level of cigarette smoke. There's no safe level of asbestos. There's no safe level of various chemicals. Case after case has said, notwithstanding that, you still have to prove that there was enough to cause the kind of harm you're talking about here, number one, and number two, that this plaintiff actually was exposed to that level of harm. That argument, no safe dose, has been rejected by the cases we cite in terms of saying we don't want people exposed to asbestos. You still have to prove the threshold dose necessary to cause the harm you're complaining of, and you still need to prove that you as an individual plaintiff were exposed to that. And their witnesses disclaimed both aspects of that proof. Dr. Nelson, in terms of general, the lower limit is not known. Dr. Settles, I couldn't comment on specific levels. Dr. Rao didn't give general causation testimony. And same thing in terms of Ethan. Dr. Settles, that's not my area of expertise. She agreed she's not an expert on heavy metals, their amount, anything like that. Dr. Nelson, I didn't do mathematical calculations, agreeing he didn't do any kind of testing. And then Dr. Rao saying, all I can say is there was a suspicion of heavy metals that needed to be confirmed. The third failure of proof on causation is the basic element of what does it mean to prove general causation. Havner, the Texas Supreme Court case, says it means proving that a substance is capable of causing a particular injury or condition in the general population. And there's a line of Texas cases that say you can't just say something causes cancer or birth defects, as in Havner, as in this court's decision in Allen and Burleson. You've got to show it's capable of causing the specific type of birth defect, the specific type of cancer. They didn't have that here in terms of the conditions everyone agrees that Ethan has, whether it's the severe autism spectrum disorder that his records extensively document and that his witnesses admitted he had, or whether it's the severe neurocognitive injury that they said at trial was the characteristic of his testimony. Both of their experts on this point, Dr. Nelson and Dr. Settles, did not give general cause opinions. They only gave differential diagnosis opinions. This court's precedent, the Johnson case we cite, recognizes that a differential diagnosis opinion is only a specific cause opinion, and before an expert can be admitted on that basis, there first must be a showing of general cause. They didn't have that here from those experts. They disclaimed those opinions. Dr. Nelson said, I'm not offering a blanket statement regarding heavy metals and baby foods. I don't have any opinion on other cases. Dr. Settles was to the same effect. No expert came in and said, looking at the specific conditions that Ethan has, heavy metals are capable of causing that condition, and that's why the district court should be affirmed on that alternate basis. I see him at time. Thank you, Your Honor.
Thank you, sir. All right, for Whole Foods, Ms. Chambers.
Good afternoon, Your Honors. May it please the court, Brad Chambers on behalf of Whole Foods Market, Inc. District Court was correct to dismiss plaintiff's claims against Whole Foods for improper joinder. Under Fifth Circuit precedent, it was right to ignore the second amended complaint, and irrespective of whether it's a second amended complaint or the first amended petition of the state court, neither pleading satisfies the requirements of Texas law to get around the exceptions to the general rule in Texas Civil Practice and Remedies Code, Chapter 82. All of Texas product liability law is encompassed within the provisions of Chapter 82 of the Civil Practice and Remedies Code, irrespective of the theory. And the general rule is a seller is not liable for harm caused by a product outside of some very, very minor and detailed exceptions, none of which apply in this case. The generalized statements that plaintiffs refer to are not specific to any aspect of any particular product, much less any product of baby food, the Hain baby food, or the heavy metals at issue in this case, and therefore are unactionable under Texas law. There is
Toxicity, the metal, that's not an aspect of the product. I'm still trying to process that.
it's not particular as the
What would
representation.
be, in the example of foods, what would be an aspect of the product?
If the representation was that this baby food had no heavy metals in it, that would be an express representation. There's a generalized statement on the website that is far beyond that. The rightful dismissal of Whole Foods meant the district court was sitting properly in diversity when judgment was rendered. And under the Caterpillar doctrine, the judgment should be affirmed, and this case should be upheld. I see my time has expired. Thank you.
Thank you, sir. Back to you, Mr. Post.
Thank you, Your Honor. I want to address the three categories that Hain's counsel raised with respect to the remand issue, and I'm going to take them in the order in which he addressed them. But let me first point out the dog that did not bark in the last 20 minutes. You never heard one reference from either lawyer to Pena. Pena controls this situation. The logic of Pena requires that a plaintiff had the opportunity to amend to meet the federal pleading standard. The defendants just don't clash with it. So what does the defendant say? They say, we have no right to amend after removal, but note that they don't disagree with what I told you in the opening argument. No Texas case requires a plaintiff to anticipate and plead around the Chapter 82 defense. That's why the logic of Pena dictates that a plaintiff had the opportunity to clarify its allegations and do so. There was discussion about the allegations that were in the live petition. I want to quote to you paragraph 62 and paragraph 64 of that petition that appear at page 169. The plaintiffs alleged that the Hain products were represented as being, quote, safe and high-quality organic baby food. And the plaintiffs alleged that Whole Foods represented that, quote, Hain's Earth's Best organic baby food products were safe and of the highest quality. Those allegations about those representations were in the petition at the time the case was in state court. All we did was elaborate on them in the federal complaint, as Pena entitles us to do. That is not alleging a new claim. Negligence was pleaded all along. A warranty claim was pleaded all along. All that was clarified was that we can satisfy the Chapter 82 exception to their innocent retailer defense. Nothing in this circuit's precedent forecloses that.
So is your theory that 61 and 63 are implied paragraphs, 62 and 64 are express, or at least potentially express paragraphs?
That's exactly right, Your Honor, and resolving any ambiguities.
It's a bit unusual to plead that way, isn't it?
It is a little bit unusual, I agree, but under Texas fact pleading practices, in which all that's necessary is that you plead facts that could give notice of the claims, that's sufficient under Texas pleading. And the Lipsky decision from the Texas Supreme Court, I think, amply demonstrates that. And so it's not surprising, and that's why Pena is correct to say, when you come to federal court after removal, you have to have an opportunity to demonstrate that your pleadings satisfy the federal standard. And ours do. So let me turn to the second point that counsel made. They said there was no viable allegation under Texas law. But all the arguments they rely on are federal district court decisions. This completely turns Erie analysis on its head. What is the answer to the Pennington decision from the Texas Supreme Court that says a representation that a product was in, quote, excellent condition and perfect condition is actionable? There's none. What was the answer to the Italian cowboy decision from the Texas Supreme Court that said that where a seller represents that a product had, quote, no problems and was perfect, that was an actionable representation? There's none. And that's because Texas law recognizes, particularly when you have a party that has superior knowledge, those kinds of representations are actionable. And what was represented here? We alleged that Whole Foods represents that it, quote, carefully vets its products to assure that they meet, quote, our high standards. That's at page 272 of the record. Whole Foods holds itself out as having superior knowledges and induces its customers to rely on those representations and pay premium prices in reliance on the assurance that Whole Foods has that superior knowledge and is curating their shopping experience. And on that note, there was some discussion that there was no representation alleged with respect to this product. I don't understand how that argument can be made in the face of this record. I quote to you from page 272 of the federal pleading, quote, Whole Foods made these express factual representations about Hain's Earth's best baby food. I don't know how that could be pleaded any more explicitly. And certainly if we accept the federalism principles that all ambiguities are resolved in favor of remand, that should be sufficient. And so that brings me to the third argument.
I'm sorry, which paragraph was that?
Your Honor, that is on page 272, and I don't have the precise paragraph reference there. The final point is their Caterpillar argument. That is a radical suggestion to suggest that even though complete diversity is lacking at the time of judgment, nonetheless, the court could affirm. It is not true under Caterpillar. Caterpillar itself said that if at the end of the day, in case a jurisdictional defect remains uncured, the judgment must be vacated. That was not the case in Caterpillar, but it is the case here. And in Grupo Dataflux, Justice Scalia limited Caterpillar by making explicit, if there is still a jurisdictional defect in the case at the time of judgment, Caterpillar does not apply. Subject matter jurisdiction is lacking, and this judgment must be vacated and remanded. If the court has no further questions, I appreciate your attention.
All right, thank you, Mr. Post. Thank you, Counsel Officer. Appreciate your robust briefing and argument. It's a very interesting case, to put it mildly, so we'll give it our best shot. Thank you. All right, we call